Cotney Attorneys and Consultants is dedicated to helping the construction industry with legal, business, and safety challenges. Welcome to this week's episode of Law Mortar with John Kenny and Trent Cotney.
Hey, it's Trent Cotney, CEO of Cotney Attorneys and Consultants, here with another episode of Law Mortar. As always, got my partner in crime, John Kenny. John, how you doing?
Doing good. It's been a long week, busy week again. Glad to be here on our favorite show with our favorite guests, Law and Mortar.
Yeah, we just wrapped up METALCON, which is the structural and sheet metal industries. And it was actually here in Tampa, which is good. I think it's been, maybe 5-6 years since it's been here.
Yeah.
Which it makes it easy on us, given that our headquarters is in Tampa. And got a chance to speak a couple of times. We had Lexi Sutton from Consulting speak today. And John, I wasn't able to attend that one, but how did it go?
That went really good. It was Lexi and 4 other panelists from around the industry, women, and Heidi at Roofer's Coffee Shop. She headed it up. She did a really nice job. Good panel. They discussed about the recruiting and retention of women in the roofing industry and metal industry in particular, with the theme of METALCON. I thought that was very insightful. There was a pretty good crowd that was there watching it too, so it was worthwhile.
Yeah, I enjoyed it. I think we had a good time. I had some great conversations when I was there, and I look forward to what they got planned for next year. Kind of switching gears a little bit, we were having conversations earlier today with Craig Brydup, who's our national lobbyist. And one of the things that I've been trying to make sure that we stay on top of is Biden's proposal that anybody that's got over 100 employees, that they were going to enforce either vaccination or regular testing, and how that was going to interplay with OSHA. So the latest is that they're going to push OSHA to come out with something in the next few weeks, but you can absolutely anticipate that there are going to be legal challenges to that. In fact, John, I think you were saying that there were several states that are already in that process.
Yeah, I heard this morning on the news that their states are already starting to file before the order's even written. So, it's going to be tangled up there for a while.
Yeah, so we'll continue to stay on top of that. I do question constitutionality of some of the effects of that proposed rule. So we'll see exactly how it's going to shape up in the next few weeks. Something else I want to turn to, I guess, on the contract side of things, and this is fresh in my mind because I was dealing with it just earlier today, is dispute resolution. It's one of those things in contracts you don't pay a lot of attention to, but oftentimes you get a choice between arbitration and litigation. And for those of you that don't know, arbitration is where you get in front of an arbitrator. It could be a panel of arbitrators. Usually it's just one. It's somebody that usually has experience in construction, and they decide your case. It's binding, but it's not in a court, right? So it's like going to court, but not. Okay. You can always go to litigation, which is in front of a judge or a jury. The pros of arbitration are it's quicker, usually very difficult to appeal. So whatever you get, good or bad, you're kind of stuck with it. And there's less discovery. So again, that saves on cost. Okay. The con of using arbitration is it's expensive, right? You're having to pay that arbitrator as opposed to going to court, where the taxpayer money pays for the judge to hear your case. So depending on what kind of customer that you're contracting with, you really want to think about what's best for you. If you are contracting with a church or a charity, probably want to be in arbitration where stuff remains a little bit more confidential. You don't have to worry about it. So, John, what's been your experience with that?
Yeah, no, I definitely have to agree. It goes per client. And you got to weigh the cost out too. If you get into a heavy litigation in a court, you may have been better off going to arbitration. But I think it comes down to definitely the client and the type of project that you're working on. I've been pro and con on both, honestly, Trent. When I've been on the other side, I've been to many arbitrations, and ones that have gone to court as well. But it's kind of a crapshoot. It really is. But I definitely agree. If it's something you don't want publicized, always ask for arbitration. And if you have a choice of having local arbitration rather than going out of state for litigation, definitely take that option.
Yeah, it could be worth it in the long run. So, we kind of err on the side of including arbitration provisions, but if you're in a small county somewhere and you're well known, you might want to, consider what your options are. Sometimes your witnesses are local, makes it easier to go do things in court. But yeah, it's definitely something that you need to pay attention to as you're entering into contracts. John, we've got some stuff next week that I'm looking at. Monday, I know I am heading over to Orlando for the National Safety Expo. I'm speaking on the OSHA inspection and citation process. Very interesting. This is the first expo that I've attended that actually requires proof of vaccination via third-party app. So I would expect that from the National Safety Council, but interesting, maybe a sign of things to come. I had to upload my information. They independently verified it. And before I can get into anything, I've got to show them that in addition to wearing a mask. So pretty heightened safety protocols. That kind of segues into what I have for the question of the day, John. So are you ready?
I am ready. My favorite time.
Okay, so this question is from Lisa. And this is an interesting question because, see if I can kind of summarize it here. Lisa was working on a new construction of a fast food chain store. And while Lisa was working on that, she was in the prime position. OSHA comes out to the job site and ends up citing the electrical contractor, cites the roofing contractor, cites the stucco erector, the scaffolding erector and the stucco contractor, all for various safety violations that ranged from failure to have PPE to you name it, right? And then OSHA ended up citing her, the prime contractor, for everything that the subs did. Now, legally, this is known as the multi-employer site doctrine, where if OSHA deems that you're a controlling contractor and you control the safety of your subs, then any of their bad acts could be attributable to you. But there are a lot of different ways that you can defend against that. Example is you got to have a great subcontract. If you don't have one that has at least a page worth of safety stuff saying that you're not responsible for, you need to look at it. We've got a great one at shopcottony.com. Master subcontract agreement and a proposal that goes along with it. It works absolutely fantastic because you issue that subcontractor agreement once. From that point on, you ever do work with them again, you just issue a notice to proceed and it refers back to that. So, my advice to you, Lisa, is that in the event that you face stuff like that, make sure that moving forward, you work on your contracts and recognize you still have to OSHA still has to prove that you had supervisory control over their safety in order to succeed on that. So you probably have some decent legal defenses to that. John, did you ever face anything like that in the field where you were held liable for your subs bad acts?
Yeah, it ended up winning, very similar to what you just said, on our favor to our side. And it was because we had the heavy duty safety requirements in the beginning, put the proof of training, and we had all that documented, and also a subcontract agreement, which I'm pretty sure at the time you probably did for us. But that's exactly how. So sum it up, yes, fine came, yes, absolutely uphill. We received it. End result is we were able to beat it exactly in the reasons that you just stated.
Yeah, and this is something that we're seeing more and more. It's a sort of a wide net that OSHA cast, and the prime usually gets caught up in anything that the subs do. So very important that you backfill administratively with paperwork to support your position, that you're not in charge of your sub safety. Of course, always have a safe job site. Every penny that's spent on safety is a penny well spent. But with that being said, John, we are at the end of another episode of Law Mortar. I'd like to thank everybody for making us the #1 construction law podcast in the world. If you got questions for John or I, you can reach me at tcottney@cottneycl.com. John, how can they reach you?
You can get me at jkenny@cottneycl.com. And if I may, before I break off, a plug, we got the Next World of Roofing coming out. It'll be out next week. So I know we got a lot of crossover in the audience. Please feel free to join us for that as well.
Yep, fantastic podcast. I learned a lot during the first episode. So make sure you turn in for the next ones. It's going to be great as we continue to go around the world and talk to craftsmen. So again, thanks, guys. We'll see you next week.
Bye now.